Hi, this is David Fowler, and I'm here with Professor Adam MacLeod at Faulkner University down in Birmingham. And today is the day we're hearing testimony on the so-called fetal heartbeat bill before the Senate Judiciary Committee. So we had a few moments to catch up with Adam before the hearing to just get a little feel for you of what his testimony will be about. So thank you, Adam, for taking a moment to talk with us.
Thanks for having me.
Glad you're here. So tell us what is the key point of your testimony today?
Well, I have 3 points that I'm going to get across. The first is that the Constitution of the United States, specifically the 9th Amendment in the Bill of Rights, protects rights that are ancient, that have existed in our legal traditions from time immemorial, known as common law rights. The second is that these include the right to life, which is known in the common law tradition as an absolute right, which means the government has no competence to take it away or to abolish it. And then the third is that the right to life, this absolute right, is enjoyed by all natural persons, and a natural person is a human being. This is someone who's not created by law artificially, like a corporation, which is a kind of person, or a chartered organization, which is a kind of person, but a natural person, a person whose existence is not owed to law.
Okay.
I mean, if you combine those three premises, of course, what you end up with is that everybody is entitled to the state's protection of their lives.
Okay, so the 9th Amendment makes reference to other rights not enumerated in the Constitution. Is that what you're really referring to here?
That's exactly it. And of course, anyone debating or discussing the 9th Amendment at the time of its ratification would have understood that to mean all of the rights of the common law tradition that we inherited from Great Britain at the time of the founding.
Okay, so as I understand, and correct me if I'm wrong, the Supreme Court's abortion jurisprudence, Roe, Casey, Gonzalez, Whole Women's Health, those are 14th Amendment analysis cases. You're talking here about the 9th Amendment. So are those cases I just mentioned, are they controlling binding precedent that you just have to stuck with, or they apply directly, and what's the point? That's what we hear about this bill.
No, they're not. The court, in fact, in Roe expressly rejected the idea that Roe was grounded in the 9th Amendment. They rejected an earlier decision of a lower court grounding the abortion right of the 9th Amendment, and just bracketed and set aside the question of the rights of the child. The precedent, the most direct precedent for this argument is the court's decision in Gonzalez versus Carhart, where the court affirmed the power of governments, the rights of governments, to protect what it calls the interests of unborn children. Of course, those interests are grounded in rights, natural rights, which children enjoy by virtue of being human or natural persons.
So would it be fair to say that this bill is trying to present a different kind of case or controversy, as we talk in the Constitution, from the kind of case or controversy we've heard before?
Yeah, it's presenting to the court, or presenting to some court that might hear this argument in the future, a different set of claimants.
Right.
And the claimant here, of course, who's been invisible up to now, except in Gonzalez versus Carhart and a couple of other cases, is the unborn human being, this natural person whose rights are at stake.
Great. Well, thank you so much. This is Adam MacLeod from Faulkner University. He's not here representing the university, so let me make that clear. He's just a friend I've met who's been helpful to me on other issues. We're glad you're here. Appreciate your willingness to testify and speak to us.
My pleasure.